much. I love coming here because I can drop my kids off at school in the morning and pick them up in the afternoon. They won't even know I'm gone. It's actually quite perfect. So the title of my talk will focus on 100 days, but goes a little bit further back. The title of my talk is President Trump has to obey the Constitution, but so does Chief Justice Roberts. Chief Justice John Roberts is on a whirlwind speaking tour, trying to single-handedly avert an imagined constitutional crisis. At Georgetown Law Center, Roberts described the rule of law as endangered. Oh, ESA protections are coming. In Buffalo, Roberts said that the courts must check the excesses of the executive. I think the job is to decide cases. What do I know? And in a statement, Roberts rejected President Trump's charge that a federal judge in D.C. should be impeached. Roberts said the appropriate response to this agreement with judicial decision is the normal appellate review process. Normal, whatever that happens to be. Roberts is quite right that the rule of law is endangered. The separation of powers are out of balance, and ordered liberty depends on a normal appellate review. But what Roberts misses is that he has spent much of his judicial career exacerbating these problems. For nearly 2 decades, Roberts decided cases based not on the best reading of the law, but based on a crude calculus of political costs and benefits. These rulings have corroded the Supreme Court as an institution, such that reasonable observers will always question whether Roberts' decisions are based on law or politics. In a recent emergency docket case, Justice Alito and Thomas declared in dissent, quote, both the executive and the judiciary have an obligation to follow the law. They both do. These judges are emphatically correct. As Roberts and his colleagues continue to lecture at Trump about weakening the rule of law, the chief should realize he shares in the blame. So let's just start back with how we got to this current moment. Rewind, right? How did we get here? The idea of Chief Justice Roberts was kind of an accident of history. If you remember, in 2005, President Bush nominated Roberts to be an associate justice to replace Justice Sandra Day O'Connor. But then suddenly, in September of 2005, William Rehnquist died, and Bush elevated Roberts to the chief seat. This spur-of-the-moment decision, more than anything else Bush did, was his most consequential decision. Long after the global war on terror ground to a halt, and compassionate conservatism, remember that? Compassionate conservatism went the way of the dodo. Roberts sits at the fulcrum of power. And at the ripe age of 70, he has signaled no intentions on stepping down. Okay. Roberts' jurisprudence can be described as situational. His lodestar is the Gallup poll. Rather than writing rulings for the ages, Roberts mediates controversies for the moment. Every case is decided based on the circumstances in which it arises. And for politically charged cases, Roberts will rule based on what is best in the Supreme Court as an institution. Okay, scare quotes. Of course, what does that mean? Little more than what Roberts himself thinks of how the ruling will be perceived in certain quarters. In practice, a chief will pursue the most conservative outcome that legal elites will tolerate. What can he get away with? He makes his own assessment of the political cost and benefit of possible rulings, decide which outcome is ideal, and then uses brilliant legal acumen to figure out the best way of getting there, whether the parties raise the arguments or not. So what will the chief's legacy be? He will not be remembered as a care for originalists or textualists like Justice Scalia. Instead, Roberts eschews any formal method of judging that could limit his discretion. Roberts will not be venerated as a stalwart of restraint, for example, like John Marshall Harlan. Instead, he has faux humility. Look at Sue's fair admissions. They overruled Bach and Grutter. They just wouldn't admit to it. Roberts not pursued any defining issues like federalism the way that his boss did, William Rehnquist. And unlike Justice Samuel Alito, his fellow Bush appointee, Roberts is all by himself on the most important case of this millennium, Dobbs. This is actually Roberts' 20th year on the bench. As I know, we've not announced any celebrations in the Federal Society for his 20th year on the bench. I think none will happen. But I will say is that his decisions will not last long. I did a casebook with Randy Barnett, and I am going through joy of taking out all the Anthony Kennedy decisions. We're just removing them, shrinking them. Like, Casey's like 2 or 3 pages now. We just don't care. That will happen to John Roberts very soon when he's off the bench. His opinions will not matter when he's gone. We will read Story, we'll read Harlan, we'll read Marshall, we'll read Scalia forever. Roberts, poof. So Roberts' defining rulings are not models of judicial excellence. Instead, they give a little bit to the left, they give a little bit to the right, and they try to split the baby. King Solomon, right? The leading case is NFIB versus Sebelius. Roberts changed his vote to uphold the Affordable Care Act, but to reach that result, Roberts rewrote a penalty into a tax and rewrote the mandatory Medicaid expansion into an optional program. And he did so during an apparently successful campaign from the left to change his vote. Few people believe that Roberts offered the best reading of the law based on neutral principles. Rather, the chief twisted and turned the law to avoid striking down Obama's signature law, while still preserving some conservative principles. More than a decade later, we're still stuck with the law that John Roberts rewrote, not the one that Congress wrote. Let's move forward to the first Trump administration. Roberts issued a troika of split decisions. First, Department of Commerce versus New York. Remember the census case? Roberts ruled the executive branch can ask about citizenship on the census, but Trump can't do it because pretext, because he has the wrong motivations. In the second case, Department of Homeland Security versus Regents in the University of California. This was a DACA case. Roberts ruled that, in theory, Trump could terminate DACA, but Trump didn't consider all the reliance interests, so he loses. So always a little bit to the left, a little bit to the right. The third case came from our circuit, June Medical versus Russo. It was an abortion case. A couple years earlier, Roberts had held that Texas's laws were constitutional on abortion, requiring admitting privileges and the like. Louisiana enacted the same statute. Roberts again changed his mind and said, no, we will let Louisiana strike down these laws because we cannot have anything that chips away at Roe v. Wade. In each of these cases, Roberts tries to find a middle ground, not because it's the best way, but because it is the middle ground. Roberts' approach continued during the Biden administration. I speak, of course, of the Dobbs decision. At long last, the court overruled Roe v. Wade. At long last. But was Chief Justice Roberts the majority? No, he was not. Did Roberts affirm Roe v. Wade in Casey, as dissenters did? No, he didn't do that. Rather, he split the difference again. I won't say split the baby, it's a bad reference for an abortion case, right? But he split, there it is, good, you guys are awake. But he split the difference again. So what did Roberts say? He said, well, Casey drew the line of viability, I'll draw the line somewhere else. I'll draw it at 15 weeks. Why 15 weeks? Well, that gives a woman enough time to have an abortion. That's good enough. So a 15-week ban is valid. He just made up a new standard because it was more politically palatable, because most abortions happen before 15 weeks. And it seems that Roberts was trying to persuade Kavanaugh and Barrett to change the opinion. Thank the Lord they didn't, because that would have kept Casey in place. Alito, in dissent, charged that Roberts was acting without any principled basis. Roberts pulled a test out of thin air that no party asked to adopt. Here, Roberts wove a new standard out of whole cloth, but this emperor had no clothes. If any of these 5 cases were considered in the abstract, they can be explained by some legal principle or another. But the arc of Roberts' career stretches over 2 decades, tells a different story. These cases were not decided by any principle broader than the chief's assessment of the political costs of the day. Obamacare, too big to fail. Census, we can't politicize that. Dreamers, oh no, we can't deport them. Abortion, third rail, can't touch that. Rather than making a best ruling based on the Constitution and federal laws, the chief engaged in acts of balancing and mediation. In these cases, Roberts split the difference. He issued a ruling that favored the left, while giving some legal victory to the right. It's predictable, it happens over and over again. The chief's apparent moderation depends on people only skimming headlines and not digging deeper. In 2020, A.G. Vermeule wrote that Roberts' most consequential legacy will be the very politicization of the court he sought to prevent. In the attempts to depoliticize the court, Roberts has done just that. And I mentioned before the baby splitting reference. Of course, we speak of King Solomon, right? But this doesn't actually work. It disregards the wisdom of the biblical monarch. Why? King Solomon never actually cut the baby in half. He didn't have to. Rather, he developed a test to resolve the dispute. The real mother could not bear to see the child harmed. This timeless principle is still taught to this day. For Roberts' opinion, your ticket's good for one ride, if that. They do not extend beyond the narrow confines of the decision. Roberts cannot lay claim to Solomon's throne, let alone John Marshall's chair. So let's move now to the topic of the day, Trump 2.0, and the first 100 days of the Trump administration. And in this short time, we've already seen an onslaught of puzzling rulings. To be sure, decisions on the shadow docket are not signed. Right? We don't know who votes. But in every case but one, the Chief Justice has been in the majority. I'll mention the one outlier in a moment. Okay? And each of these cases has the hallmarks of a Roberts compromise. Let me walk through them one at a time. The first case is Besant versus Dellinger. Okay, so who's Hampton Dellinger? Actually, if you know Walter Dellinger, it's his son. Hampton Dellinger was the head of the Office of Special Counsel. This is not the Jack Smith Special Counsel. This is a whistleblower agency. He's appointed to a fixed term. Trump came to office right away and fired him. Of course, the federal judge immediately said, no, you're not fired. You have to be reinstated. This case raises some very difficult issues. In all prior removal cases like Humphrey and Morrison, the person wasn't actually seeking reinstatement. They were seeking at most back pay. But here a judge ordered recognition. This order ran directly against the president. You must recognize this person as the official. Mississippi against Johnson says you cannot enjoin the president. Yet, district courts in D.C. blew past all this because they had to stop the autocracy from coming. So again, the lower court ordered the reinstatement of this official. What did the Supreme Court do? They did something weird. They sat on it for several days. They sat on it and they waited. And the district court's TRO was set to expire on a certain date. And the court waited for the date to happen. And the court said, well, the lower court order is expired. So there's nothing for us to do here. This is moot. That's not how law works. If there's an order that runs against you, it doesn't stop working on a certain date. It remains in effect. The court's just making stuff up. Justice Gorsuch and Alito dissented. So I'm not sure about Thomas where he was in that one. But this was a bizarre place. So what happened? Hampton Dellinger actually resigned after that. He said, forget it, I'm not going to win this fight. But the Supreme Court basically blinked. They said, we're not going to reverse an obviously wrong ruling that enjoins the president. Look at Judge Greg Katz's panel opinion on that one. He's exactly right. You cannot issue an order against the president. They said, oh, work on it. We'll enjoin the Secretary of the Treasury. And who does that secretary work for? The president. So this was a short-term victory for Trump, but it left open the issue of who else Trump could fire. See, the court could have resolved this issue like in January, but now we're almost in June, we still don't know the answer to this question. We're going to sense a pattern. This will repeat over and over again. The second case was infuriating. They all are infuriating. This one really infuriates me. I have a threshold for fury with John Roberts, right? Department of State versus AIDS Vaccine Coalition. This was a Doge case. I don't even know what Doge was 6 months ago. I didn't know what it was. Right. But the Department of Governmental Efficiency started cutting funding for a wide range of programs. And in almost all cases, these are called what termination for convenience. That you can basically end them for whatever reason you want. Okay. So the usual rule is if the government breaches a contract, what do? You go to the U.S. Court of Federal Claims, right? You bring a suit under what's called the Tucker Act, or the Little Tucker Act. It's a special court where sovereign immunity is waived, and you can appeal this up to the federal circuit. The Court of Federal Claims cannot issue national injunctions. They're not allowed to do that. They can have trials, right? Actual court. But what happened here when the executive cut $2 billion of funding? They ran to a federal court in California, because of course that's what you do. Oh no, I'm sorry. This was D.C. The other was California's the other one. It really doesn't matter. And if you're on either coast, it doesn't matter, right? You know which way it's going. I love being in the middle. We're in the middle now. Middle's good. what Scalia called the vast in-between, right, in Obergefell. So a federal judge in D.C. basically ordered, you must pay this $2 billion immediately. And the government said, we are not physically capable of it. There's so many mechanisms and protocols to follow. We can't do this on a dime. And the judge says, I don't care. You pay it tomorrow. We'll hold you all in contempt. We're going to lock you up. Right? Send you to CCOT, right? So this goes to the Supreme Court. Another weird thing happens. The government says, please block this order. You need to block this order. We cannot possibly comply. So what does the Supreme Court do? They deny the government's request to block the order. I'm not done, though. There's no period. There's a pause. They deny the government's request, but they also tell the district court to clarify your ruling. Huh? Wait a minute. If you are a court and you deny the motion, that's the end of the sentence. You can't deny the motion, still issue instructions to the lower court. There's no jurisdiction for that. You can't do that. If you deny the motion, that's it. You get no relief. You can grant the motion in part. Right? You're allowed to do that. Say, we grant the motion and we say clarify, but they denied it. Why? Because Roberts wants a headline. Supreme Court rules against Trump, denies Trump's motion. That's what matters. And then the next sentence, they say, oh, by the way, please clarify the ruling because you can't actually expect us to do this. And what did the judge do? He clarified the ruling. He reduced the amount of money they had to pay. It wasn't $2 billion, it's a number less than that. So again, the court is playing games with you. It's depending on you not knowing what the hell's going on. If people like me read this stuff, who reads this? Me, right? They're playing games with you. Shame on the conservatives for joining this ruling. They should be pushing back harder. Yeah, the AC just shut off. It's really uncomfortable in a minute. Okay. The third case is called the airplane case. This case infuriates me for sure. Trump versus JGG. This is our good friend Jeb Boasberg. He actually goes by Jeb because his initials are J-E-B. He goes by Jeb. Jeb Boasberg. Guy's like 6'7" apparently. He's very tall. I've never seen him in person. Jeb Boasberg. On a Saturday afternoon, you have migrants in the great state of Texas who are being prepped to be removed to El Salvador. Somehow, a federal judge in D.C. asserts jurisdiction. Now, I remember habeas. Actually, my habeas professor was Jonathan Mitchell, a very smart guy, said, for habeas, jurisdiction is where the custodian is, right? I mean, this is the rule that's been around for 800 years or so, right? It's Magna Carta, right? You go to where the prisoner's being held. But no, they run to a federal court in D.C., but they don't bring a habeas action, right? They say, Judge, we want habeas. And Judge Boasberg says, no, I don't think you want habeas. That's not the action. You should bring an APA claim. The judge told them to refashion their claim. You ever judge, Corey, don't do that, right? You ever judge do that? Say, you brought the wrong cause of action. Here's what I want you to bring. Who the hell is he? Is he a lawyer or is he a judge? Which side is he on? Right? Lady Justice is blind. He's giving them briefing advice. And then he said, okay, good, now you have an APA claim. I'm going to provisionally certify a class, done. In one sentence, I'm certifying a class, done. And make sure a global injunction, done, without any briefing, okay? Government has had no time to prepare. And I'm ordering you to turn the planes around. If any planes are in the sky, you turn them around. Send them back here. And any planes in the ground, you cannot take off. The government lawyer, again, this was on a Saturday resume. Probably had no idea what the hell was going on. And I can tell you, no planes were turned around. Planes landed in El Salvador, and these aliens were put into the facility. Then this judge later had the chutzpah, and he said, I'm going to hold you guys in contempt. I'm going to hold you in contempt because you didn't follow my order immediately and had no briefing done. Thank the Lord, the panel at the D.C. Circuit, which will not last. It was cats us round, the other one doesn't matter, right? Sorry, thank the Lord. Right, but it doesn't. But they said, no, you can't hold them in contempt while this case is proceeding. Okay, so the case goes to the Supreme Court. And what does the Supreme Court do again? They split the difference. They said, well, of course, under the 800-year-old rule of Magna Carta, you can only bring the case where the custody is, right? In Texas, but not Lubbock. We'll talk about Lubbock in a minute, right? That's a good Judge Hendricks in a few minutes, right? But you must bring this case in Texas. But, John Roberts says, you can still review removals under the Alien Enemies Act. Whoa, that was not the issue presented. Right? That's a very hard merits issue that I'm not even sure the answer of. And they just put this in there. I regret that Clarence Thomas joined this opinion. I regret it. Not often does Thomas I say he's wrong. He was wrong. This conflicts with his Hamdi decision. If you read his Hamdi decision, he says, alien enemies, you get no due process. 0. I'm not sure how CT joined this one. I think he might regret that one, but we'll see. So again, the court ruled, put down the Seeley application. Blackman criticizes Clarence Thomas, who get approved in 5 seconds for not being conservative enough, right? But the court ruled for Trump, but they quietly snuck in this minor issue. Now courts can now review every facet of the Alien Enemies Act, a 200-year-old statute. All right, let's go to the 4th case. Our favorite Maryland father, Abrego Garcia. Okay? So, no? I don't know. So a local court ordered the return of Abrego Garcia from this El Salvadorian prison, CICOT. Okay. Again, a federal judge, I think she was in Maryland, Judge Zinnis with an X, I'm not sure how to pronounce it, ordered that the U.S. government must return an alien in foreign custody. We don't have custody of him, but we must return it. And the 4th Circuit affirmed, said, yes, you must return him immediately. And the failure to return him will result in criminal contempt. Do we send in the Navy SEALs to CICOT and restore him? I mean, Trump can make a request to be sure, but it doesn't be granted. I mean, you want to just dump on the Salvadorian president, but he's his own president, right? He doesn't have to do what we say. So the case goes to the Supreme Court. And once again, the Supreme Court splits the difference. It's sensing a pattern, guys, right? So you say, we're not ordering the return of this alien who's in another sovereign's custody, right? But the government must facilitate. That's where we facilitate the return of the alien. What does facilitate mean? The court wouldn't tell us. So again, Trump didn't really lose. He didn't really win either. Because it reaffirms the principle that we will scrutinize everything that you do. Abrego Garcia is still in El Salvador. He's kind of fallen off the headlines. It's a big, beautiful bill. I think people care about right now. Right? It's amazing how these stories kind of just vanish. No one just cares about them anymore. The Maryland father, we just don't talk about it anymore. He's still there. All right. So far, Roberts only been dissent in one shadow docket ruling. Okay. Actually, Steve's still here. Can I still say shadow docket will appear? No, I think he's in D.C. So this case is called Department of Education versus California. Again, the government dozed, I think, $20 million in funding for a school district. Facts might be fuzzy, not important. And a federal judge in California said you must pay immediately. Again, they should go to the Court of Claims. So again, here the court said by 5-4 vote that these suits must belong to the Court of Claims, not in California. Roberts was in dissent. He didn't explain why. So Justice Barrett flipped her vote. In the AIDS case, she said that, yes, we will order this money to be paid, but here she said, we will not order the money to be paid because it's in the wrong court. I don't know how you reconcile that. I really don't. Justice Barrett, maybe she's had second thoughts about the precision. I don't know. But this was a weird flip. But Roberts didn't write and explain. He never writes a dissent. He just says, I would grant the application. All right. But now I want to come to, I think, it's the most troubling one and involves this state here, Texas, in many ways. So the ACLU represented a Venezuelan national named AARP. Those are his initials. It's not the American Association of Retired Professionals. His names are AARP, and I swear to you, not. The other habeas petitioner, his initials were FGM. You know what that stands for? Female genital mutilation. Right. Those are so you have ARP and FGM. Anyway, these are the two. Now it's WMM. They found another guy. It's better. And here's what happened. These people are being held out in West Texas, which for you, I understand is in the Northern District of Texas. I don't understand why, but out in West Texas near Lubbock, and I think Abilene. The ACLU went to Judge Wes Hendricks, who's a federal judge in Lubbock, and said, we want a TRO to block the removal. We want to certify a class for all the aliens in this district. Judge Hendricks initially said, you've shown no evidence these people can be removed right away. I'm not granting a TRO. I want to walk through this chronology here to understand what happened. On the afternoon of the 17th, on Thursday the 17th, a voicemail comes in. And the ACLU, I kid you not, asked for a TRO on a voicemail. Can you ask for a TRO on a voicemail? No, you cannot. That's called an ex parte communication that only the judge sees. There are local rules that prohibit. In fact, the Code of Conduct says you cannot call a judge and ask for relief. Anyone have a district court clerk here? How often people call you and ask for the phone? You can't do that all the time. But the ACLU asked for a TRO on the phone. So then Judge Hendricks, to his credit, issues an order saying, please put something in writing, and I will give the government 24 hours to respond. Don't give me this stupid, I'm going to ask you on the phone. Okay, fine. So now we go to Friday the 18th. Good Friday, if any of you were celebrating. Or, I'm Jewish, I don't know. Do you commemorate Good Friday? I don't know. What do I know? What do you do? Do you celebrate Good Friday?
Yeah.
Good. Okay. Good. I don't know. Yeah. Okay. Good. So you commemorate. Anyway, so this was Good Friday. At 12:34 a.m. on Good Friday, so at half hours after midnight, a emergency TRO comes in the docket at midnight. Do you think any judge sitting at his computer at midnight refreshing ECF saying, I wonder if any TROs can be filed right now? The answer is no. So that morning, the morning of that Friday, Judge Hendricks wakes up, and I suspect he saw there was a TRO. Oh my goodness, I gotta act on this quickly. And wouldn't you know it, he had already said the government gets 24 hours to respond, so he was going to let the government have 24 hours to respond. That was the court's order. Okay, fine. Around 12 o'clock in the afternoon, the ACLU filed a motion for an emergency status conference, in which they say, I swear to you, if you do not rule on our motion in 42 minutes, we will take an appeal to the Fifth Circuit. 42 minutes. And we ever see Hitchhiker's Guide to the Galaxy? Number 40 is just magical, right? 42 minutes. Somebody got that good. 42 minutes. Can you imagine? Maybe he works in the Texas AG's office. If you demand Judge, I don't know, Ezra, rule in 42 minutes, he would throw you into the river, right? He would. I think he would actually order the marshals to arrest you. 42 minutes. And they had no clear evidence that removals were imminent. In fact, the government said, we will not remove any of the named defendants, or the named plaintiffs during this time. Class defendants, different story, because they don't exist, but people who are actually filed a petition will not be removed. Needless to say, Judge Hendricks did not rule in 42 minutes. This is a complex case with a lot of moving parts. So they filed an appeal to the Fifth Circuit. And as you all know, when you file an appeal, you divest the lower court of jurisdiction, right? The district court cannot act anymore. It goes to the Fifth Circuit. A panel of Judges Ho, Wilson, and Ramirez. If you don't know Judge Ramirez, I have no respect for her. She's a Biden appointee. She was a magistrate for 20 years. Fifth Circuit dutifully works on it. They spend the entire evening, it seems, writing an opinion. How do we know this? Because shortly after midnight Central Time, Fifth Circuit releases an opinion. The unanimous panel says that we have no jurisdiction because there's been no lower court ruling, right? Judge Hendricks hasn't ruled in the motion. This is premature, right? We can't take jurisdiction with no lower court ruling. In fact, Judge Ramirez, again, who was a magistrate for 20 years, says the judge here is behaving properly. There's no constructive denial of the TR. You can't give a judge 42 minutes. That is insane, right? That is insane. You can't do that. But little did the Fifth Circuit know that at the same time that the Fifth Circuit was dutifully working on the case, the ACLU also ran to the U.S. Supreme Court. And you know what else happened on Good Friday evening? Judge Boasberg had an emergency hearing. Even after he got smacked down by the Supreme Court for telling him that you don't have jurisdiction, he still had a hearing. And you know what he did? He demanded to know from the government, do you plan to remove anyone in Texas? He's asking questions about something and another. This man is drunk in his own power. Right? He's lost his way. And apparently one of the lawyers for DOJ said, we don't plan to remove anyone today, not really sure about tomorrow. And this ACLU says, that means they remove them tomorrow. So they go to the Supreme Court, and they even disclosed information that Judge Hendricks didn't have when he made his ruling. So around the exact same time, within minutes, that the Fifth Circuit rules there's no jurisdiction, the U.S. Supreme Court says, we are going to enter a stay. A stay of what? There's no lower court ruling. They stayed the executive branch. That's not a thing. You can issue an injunction, the executive branch, but you can't stay the executive branch. And they issued relief to a punitive class that no lower court had ever certified. We don't know who this class is. These people can be removed on other grounds. It'd be like murderers and rapists who can't be removed because of this order. And then worse still, they violated Marbury versus Madison. For sure, right? What was Marbury? And my students here, right? Marbury held that the Supreme Court's original jurisdiction is fixed. You can't expand original jurisdiction. You have to use some low court decision, right? When the Supreme Court ruled, there was no lower court decision. They legit decided this in the original jurisdiction. I made this point, people go, Will Bode and Jack, oh, Blackman, you're wrong. Okay, Alito just echoed me, so I got it, right? This was a Marbury violation. They just made stuff up. They were so hell-bent on not letting John Roberts support these poor people from these camps in West Texas that they just made up these rules. They certified a class on the fly. They ruled in a case with no lower court decision. They expanded the original jurisdiction, right? And they did all this with no briefing from the government, based on Judge Boasberg's questions in an unrelated hearing where he clearly lacked power. This is not a court. This is not a court. This is a mediator. Like, there's a labor strike now, we kind of mediate it. They're mediating. They're not deciding cases anymore. Alito and Thomas dissented, saying we'll write dissent later. I'll get to that in a minute. Shame on Gorsuch. Shame on Barrett. Shame on Kavanaugh. They know better. They know better. They know better. A couple days later, Justice Alito wrote his dissent. I'm just going to read you a sentence from the dissent. He said, in sum, literally in the middle of the night, the court issued unprecedented and legally questionable relief without giving the lower courts a chance to rule, without hearing from the opposing party, within 8 hours of receiving the application, with dubious factual support for this order, without providing any explanation. For all the complaining about the shadow docket, Vladek's not here, but I still hear him, right? This was the most egregious shadow docket order ever, by far. And it comes in the context of national security. I get it, John Roberts thinks Trump is bad, but he has the power. He was elected. You get stuff when you're the president. You get the keys. You get the Alien Enemies Act. You can invoke it. And now a month later, the injunction remains in place. What happened? Just on Friday, not even 4 days ago, we had a decision from the court. The court, this part makes me very mad. The court found that the failure of the trial court to rule in a compressed time was a constructive denial of a TRO. So first they said, well, it's not 42 minutes, right? The motion was called at midnight. We start the clock at 12:34 a.m. Excuse me? You expect judges to be awake in the middle of the night responding to TROs? In what universe? We have a 6-month list for judges who can't decide motion in 6 months. You mean 12 hours? In what universe? I mean, Amy Coney Barrett's never naming a pleading in her life. Maybe she doesn't know better. Sotomayor knows better. Jackson knows better. And let's say it was 12 hours. Are we really going to say the failure to rule on something in 12 hours is a constructive denial without giving the governor a chance to respond? The court threw Wes Hendricks under the bus. He's a good judge, and he worked his butt off to get this stuff out. But the court didn't care. Number two, the court said that a district court can certify a class during a TRO hearing without following Rule 23. What the heck is that? Congress passed Rule 23 for a reason, right? There are rigors to have a class certification. In fact, the CASA case, the birthright case, is all about classes. The president said, yeah, you can just make it up for emergency relief. In other words, when the ACLU says there's a big emergency, stop whatever you're doing and just rule for them and figure out the details later. Screw the executive branch. That's the upshot. It's if there's an ACLU ruling that needs to be had, just rule for them now and figure out the details later. And if you have to certify a class and ignore the government, it doesn't matter. Just stop Trump now. That's the bill that Roberts, stop him. Stop Trump now. Use your power to stop Trump. There's a problem, though. As Justice Alito told us, the executive has to follow the law, and so does the court. So, just yesterday, Ed Whalen, who writes at National Review, had a post, and he says, let's assume that Alito's right. Let's see if the court really messed up here. Who do you blame more? Whalen says, I'm going to blame Trump more. Right? Trump caused this entire problem. He deserves the blame, not the court. This is 100% backwards. Donald Trump is who he is. He promised on the campaign trail to use the Alien Enemies Act. He said this. He got voted for. He won. And on day one, he came to office. He signed his order and kept his promise. There was virtually no precedent on the statute before. Nothing bound him. Nothing said you can't do this. He issued an order. I think Trump's actions are far more defensible than Biden's about student loans and eviction moratorium. These were clearly illegal acts. They did even after the court told him to stop. And Trump, to his credit, has said, I will follow Supreme Court ruling. I think he will. But Trump is accountable, right? He has suffered political losses for moving aliens under the AEA. And I think these actions might help the Democrats take the House in the midterms, perhaps. And when that happens, we'll see hearings, we'll see subpoenas, we'll see investigations, and probably another impeachment for abuse of power. Remember abuse of power? I remember it. But what are the consequences when the Supreme Court abuses its power? Oh. Chief Justice Roberts has lectured us that judges cannot be impeached for their decisions. I think he's right. He says the only remedy is the normal appellate review process to the Supreme Court. But what happens in the Supreme Court is at fault. Remember Justice Alito's flag, appeal to heaven? Can we appeal to heaven? No, we can't. Brutus, the anti-federalist, warned that Supreme Court justices who were, quote, independent of the people, of the legislature, and have every power under heaven, would soon feel themselves independent of heaven itself. Brutus, as usual, is right. In the Chief Justice world, he is the alpha and omega. He determines what is legal, and his determinations, therefore, are legal. I am the state, as the king would say. So I think, again, Whalen is quite wrong. The standard for the Supreme Court must be much higher. The Supreme Court should avoid even the slightest hint of impropriety. Yet in AARP versus Trump, the court misstated the facts. They slander the good name of Judge Wes Hendricks. They manufacture a new legal principle out of whole cloth. And they curtail the executive's power and expand the Supreme Court's original jurisdiction, all on the fly. All this was done to hold a policy and invoke the 200-year-old authority that was a centerpiece of Trump's campaign. Only Thomas and Alito had afforded to call out the majority. Justice Kavanaugh, to his credit, said, I would side the merits now. But look, if we're going to assign blame, the Supreme Court warrants far more blame. It's unaccountable. Trump is accountable. And I don't think this comparison is even close. Let me end with another sort of framerish thing. Hamilton said the judiciary is the least dangerous branch. I agree with him. Unlike the Congress, which is the power of the purse, and the president, the power of the sword, the courts just have their judgment. Yet, it's sort of deeply ingrained in our national psyche that the role of the courts is to balance power of the elected branches. That's not true, right? They're just two jobs to decide cases. It's not to balance powers, right? Roberts says, we must check the excesses of the executive, but who will check the excesses of the judiciary? The greatest check in the courts can only be a belief, a widely held belief, that the court is not ruling based on politics. But if the people believe that the judiciary is just another mediator that weighs political compromises, the courts cannot long endure. Thank you very much. And I welcome your questions. Yes, sir.
I agree with you. That was probably the most egregious order by the Supreme Court. But I would also argue not the most egregious order that ever came out of the Supreme Court. I would argue that was probably during the Vietnam War when Justice Douglas sought to enjoin the bombing of Cambodia.
Yes, sir.
And what happened there actually happened is the Supreme Court as a whole, just a few hours later, reversed Justice Douglas, which I'm not so certain that would happen nowadays. many tanks does Chief Justice Roberts have?
Yeah, so if you don't know the history, that's a fascinating history. This was the ACLU in the 70s, found Justice Douglas at his home, I think it was in the mountains of either Washington State, somewhere out west, and they actually held a hearing at the local post office. And Justice Douglas, by this point, he was gone, right? And he actually issued a global injunction to enjoin the bombing in Cambodia. And then the government ran to the Supreme Court in D.C., and within, I think Patrick's right, within a few hours, they reversed their brother's ruling. The only difference here is that Judge Boasberg said planes turn around, and no one stopped him. The D.C. Circuit said, yeah, that's fine. Supreme Court got to it about a week later. I think we're living in a very strange time where people, again, if you think that Donald Trump is the threat to the rule of the law, then you can do anything to stop him. Then you become the threat to the rule of the law, right? It's not a one-way ratchet. Both sides have a role to play. But good question. Yes, sir.
Professor, I think you've made a compelling case that Chief Justice Roberts is maybe sort of a slightly more conservative in results version of Sandra Day O'Connor or Anthony Kennedy, but you haven't talked much about some of the other judges like Justice Barrett. And could you give some comments, because there's been some in casual circles, some alarm at her behavior lately.
Yeah, Justice Barrett, she doesn't like me anymore. Look, I wrote a great piece for the Texas A&M Journal Law and Civil Governance about this with the 3 Trump appointees. I won't bore you with all the details, but I think Justice Barrett is coming under the sway of the Chief Justice. I think she kind of was thrust in this position, wasn't really ready for it, and Alito and Thomas are not the most warm and fuzzy types. So I think Roberts is just giving her a place to be. I think Kagan's also pushing Barrett to the left. Justice Gorsuch, he seems lost right now. Like, he overruled Chevron, and like, what are we gonna do now? Right? What's left to do? Right? That was just, he was put in the Supreme Court to overrule Chevron. He did it like in 4 years. Okay, what now? What next? Non-delegation, not going anywhere. Major questions, right? So I mean, Gorsuch has been sort of weird. He also has this sort of civil libertarian streak that I think is having him vote against Trump in a lot of these cases. Kavanaugh, again, I dumped on Kavanaugh a lot. He's separating himself from the other 2 Trump appointees in a good way. He actually didn't join the Roberts opinion in the ARP case a few days ago. And Kavanaugh was asking some very good questions of birthright citizenship. I think he may actually end up being the best Trump appointee. I can't do him things out loud. I think he might be. But Barrett, I think, is just, I think she's adrift. And Gorsuch just seems off. I think he's just TDSing a little bit. Trump duration syndrome. It's getting to him just a little bit late onset. Yeah.
Josh, similar question, but sort of in a bigger macro picture. Your views in terms of Congress, on the one hand, going back to your Rule 23 point, as well as, if you are DOJ or White House counsel now, how do you deal with this situation? What's your advice?
I mean, part of the problem is, people complain about forum shopping. Oh my goodness, Matt Kazmarek, Reed O'Connor. Libs don't need to forum shop. They don't need to. They just go to D.C. and they get whoever they want, right? They go to San Francisco, get whoever they want. They get their judges. And these judges have ruled against Trump on virtually every single issue. So if you're a DOJ lawyer, your only prayer, your appeal to heaven, is to appeal to the Supreme Court. And I think Robert's signal is, I'm not going to bail you guys out. I'm going to make some really terrible law. So unless we get another vacancy and make Roberts the 4th vote, I'm not quite sure what the remedy is. Now, in terms of Congress, the big beautiful bill, whatever else, I don't know what the hell they're doing, right? I think Congress could have fixed the nationwide injunction issue, but they're not going to. And there's an asymmetry, right? When there's a Republican president, Dems love the national injunctions. And there's a Democratic president, Republicans love it. My friends in the Texas AG's office use them casually, I should say, right? The challenge, though, and this is his credit, do you stay the injunction, right? Matt Kazmarek, to his credit, would stay his injunctions, give a chance to appeal. Judge in D.C., they don't say, they say, you turn those planes around, you spend this money right away, and the D.C. Circuit's not stopping it. What you can't have is basically a 28-day ruling from a judge, a 28-day TRO from a ruling that cannot be appealed, and the Supreme Court won't do it. You can't have the executive branch handcuffed for a month without any appellate process. That cannot stand. And I think the Supreme Court signaled we will review this earlier, which is good. But for the first month or so, you had the First Circuit saying, well, we can't really take an appeal from a TRO, maybe seek mandamus, and then we just wasted time. Okay. Corey?
Isn't what the Supreme Court needs if they want to stop this to just TRO emergency posture. It's not a proper, full, prepared court hearing with evidence and a record adversary. But like the TRO is like essentially no record, right? It's just sort of very quick. Like, it's a true emergency.
Self-serving, in fact.
Yeah, and so a temporary injunction is still not a full rules of evidence kind of argument. And so there's a way to say we are not allowing any more of these emergency orders, but that doesn't mean we're ruling for Trump. We're just saying we don't. The proper, like, you just fill it with procedural jargon, just like imminency or whatever. Just like, so we need to wait until.
So look what the Supreme Court did on Friday, though. Roberts says you don't have to follow the procedures of Rule 23. You don't have to follow the rules of evidence. Even ACLU self-serving testimony, hearsay, is enough to grant a global injunction. That's why this order, Patrick's point, was the worst. They didn't just rule against Trump. They said what Judge Boasberg did here is okay. That if the ACLU runs with their hair on fire and says, we got a text from someone with a blurry photo of an order saying that maybe we remove tomorrow, and we're not really sure, but grant a global injunction anyway. Robert's like, yeah, no, go ahead and grant that. Just grant that, right? If we want to focus on, Justice Barrett's been praised as a proceduralist. Yeah, right. Okay, this was a procedural abomination, right? There are so many reasons to go with Alito on this one. Alito's dissent is one for the ages. I think it was quite well done. It was through the chronology point by point. The number of hoops you have to jump through to get to this ruling is sort of startling. So, Corey, I'm with you. I would hope they say that more to get a global injunction, but these groups are getting them based on speculation. Again, when
you reward people for accosting you in the parking lot with a piece of paper and a text message, you're going to get like 5 more people next week, right? Because you're just telling them that it works. Yeah.
Again, I don't want to make light of Judge Boasberg, but he's holding hearings where he clearly lacks jurisdiction and demanding concessions from the government. He's literally like Torquemada, right? He's an inquisitor of the Trump administration at this point. Hey, Torquemada, what do you say? History of the world? Anyway, go on. Happy Good Friday, everyone. What else? Yeah.
Thanks so much for coming out, Professor. Just to kind of like think about it from the justice's perspective, somebody's judge's perspective, I think what might be going through some of their mind is they see Trump load a bunch of people on a plane and try to ship them out immediately.
Yeah.
So when the ACLU says, well, this might happen, they think, well, there's some point to that. So I understand there's all sorts of weird ways like that. It seems like we can't order the executive to tell another country to bring somebody back. But like, should the court do in this chance? Because when you see people just like swept up without any process, and we're supposed to just trust that they're bad guys, and then that they can be sent to a prison in a foreign country, and nothing can be done about it. What should the courts do?
Yeah, no, it's a fair question, right? So it's clear that Roberts and colleagues don't trust Trump. They think they're playing fast and loose. They're trying to remove people on Good Friday, on Saturday afternoon, without giving adequate process. They're saying that Maryland father down to CCOT, and they're not returning him, even though Trump probably could demand a return. So I get it. There's a lack of trust. So I'm going to answer your question more globally. Courts can't fix every problem. I'll say it again. Courts cannot fix every problem. There's sometimes bad things happen, and courts don't have the power to stop it. Now, we learned in Marbury, every wrong has a remedy, right? That's actually not true. Not true at all. Ask any practicing lawyer. Lots of wrongs are not remedied in the judiciary. There's political costs as well. If Trump is truly disappearing people, the U.S. Senator visited him, right? But if Trump is disappearing people, there's a political cost to be had. Last week during the birthright case, there was a lot of discussion of judicial supremacy and Cooper against Aaron. And it's his belief that the courts are oracles, that we can look to them for guidance, for help. And it's a myth. And if Trump can puncture that myth, he will go down in history as one of the greatest presidents ever. If he can actually puncture the myth of supremacy of the courts, it will be remarkable. And it will be John Roberts' self-own, right? Every effort to say we can fix every problem. Bob, can we fix it? Yes, we can, right? You can't fix everything. You can't. You can't. So yes, there might be a small number of people who removed improperly. And maybe there's political cost, maybe there's not. That sucks, but like how many people in our own country? Those are cases in the Supreme Court where a death penalty applicant filed his petition a few minutes late. They said, sorry, procedural default, you're executed. We've had U.S. citizens executed for less error than this. Right? How many people were in jail based on screwed up police work, right? I don't want to make light of it, but the law ain't perfect. And not every error can be corrected. EDPA, if anyone does EDPA litigation, it's actually very hard to find actual innocence. To actually vacate a conviction, maybe not in this district, but generally it's very hard to vacate a conviction, right? People who legit were innocent are in jail, U.S. citizens. So again, if these aliens who, by the way, almost certainly removal on other grounds, get to CCOT quicker, that's not the end of the world. But the court can't sustain, because their myth depends on them being these sort of demigods, that they'd be able to solve everything. And I think we need to puncture that myth. Good question, though. Yeah, in the back.
They open up Rule 23, essentially the only thing that goes, that is to just certify classes on the fly. Should we be concerned about the impact on normal civil litigation?
Oh my God, yes. Oh my goodness. Can you imagine how many plaintiff lawyers are salivating at this? That you can certify a class on the fly to seek a TRO? That failing to rule in 14 hours is a constructive denial? But has anyone ever gotten a constructive denial? Does it ever work for anyone? Like usually, 6 months, maybe a year, right? I know Texas has tried a couple times. Did it ever work?
We got to Scotex on that one.
Maybe once?
Denial from the intermediate.
And how much, remember how long that one waited for? Months?
I think they set a briefing schedule that was like days in advance.
Right. So in other words, the court sets a briefing schedule that doesn't even allow. By the way, Justice Jackson, by the way, has done a new thing in Kagan too. The government goes to the court in the shadow doc, says, we want a ruling by a certain date. And Jackson sets a briefing schedule after the date.
Right.
Forget ruling, she won't even brief it. Justice Kagan hasn't even called for a response in the pending shadow doc case. They're dragging their feet. So again, this nonsense of constructive denial, that's dangerous, right? How many lawyers say, 14 hours, we didn't get a ruling, go to the Fifth Circuit. What's the Fifth Circuit going to do? We filed a ruling at 2 in the morning, you didn't reply by 6 a.m., my goodness, we did interlocutory appeal. Like the Supreme Court is not thinking these things through, they're just going. They're doing it on a day-by-day basis when you need to get by, and we'll figure out the details later. It's not a court. What other questions? Yes, sir.
A little more on the political side. What do you think about Trump's ability for the tariffs, for any tariff? Like, do you think that's how do you nail them out?
Yeah, I think the NCLA filed a lawsuit. New Civil Liberties Alliance filed a lawsuit against the tariffs. I've not looked at it super close, to be honest. I think, look, if these lower court judges want to reinvigorate the non-delegation doctrine to own Trump, fine. Right? In other words, if you actually want to say that this statute delegates too much power, good, but do that somewhere else also. Don't just make that tariffs. It seems to me that Congress has power over foreign commerce, that maybe Congress should be doing this, not delegating that power. That seems like a good rule. But then again, many presidents have done this before. So are we going to disable Trump from exercising the powers of his predecessors, like he's done elsewhere? So I'm kind of mixed. Ultimately, I think it's a political question, right? Whether the president can have these tariffs or not, whether they're ever going to affect, I have no idea. So I don't have strong thoughts there. Sorry, I didn't answer your question well. I actually do pick and choose what issues I read about, so I have to be somewhat judicious. There's too many issues. Yes, sir.
Are you ever going to see any judges impeached, or is it just politically impossible?
I don't know, impeach the chief. I don't know. I mean, look, if Trump was impeached for abuse of power, can a judge abuse his power? Right? Roberts tells us that the response to a judge who screws up is the appellate review process. That makes sense unless it's the Supreme Court screwing up. What do you do? I mean, literally, what do you do if a Supreme Court justice abuses power and there's no review beyond him? Jurisdiction stripping? I mean, there are other things you can do, perhaps, but that doesn't fix a past ruling. And the court will simply declare that jurisdiction stripping unconstitutional, right? We've seen this in other countries where courts asserted too much power, right? Madison, right? If men were angels, we'd no government. We're not angels. We all have our flaws. And when you're in office for decades and no one ever tells you you're wrong, you start believing it. You drink your own Kool-Aid. I don't think we're anywhere really close to that possibility now. But I think the court has to just sort of take stock of where they are. This is an issue, like an 80-20 issue. Removing these people, that's an 80-20 issue. Like in 30 years, we'll say, why did the Supreme Court rule in 8 hours to make the people not go to a prison even though they were illegal aliens? No one will get this ruling. It won't make any sense to people in 30 years. It's just because of Trump. What else? Yes, go ahead.
Well, the challenge of all that kind of goes back to the Ed Martin scenario from just, recent weeks, right? In terms of going back to the political side,
Yeah.
and that was the key decision going back to Lothrop Wright, right? In terms of the feedback that the court gave in that one, right? In terms of what exactly, and that, which kind of goes back to my specific question in terms of
Yeah. I mean,
what can Congress do in terms of
right. So look,
the 23 context.
Ed Martin was, the appointed to be U.S. Attorney for D.C. and he made some people angry. He sent a demand letter to Georgetown. He tried to investigate various people, and Senator Tillis and others said, "We're not going to confirm you." And that was it. So now we got Jeanine Pirro instead. It's actually a hard question how long Jeanine can serve for. In theory, at least, if she signs an indictment past the relevant date, the indictment may be deficient. So this is actually very risky. This is not like a costless move. Maybe Trump will pull her at the last minute. I don't know. All right. What else? We good? We good?
What do you think they're going to do about nationwide injunctions?
Oh, yes.
Well, so if you were to ask me Thursday, I'll give you a different answer than Friday. So what's bizarre is that when the court argued the nationwide injunction case on Thursday, they knew it was coming in ARP. They knew they were going to say, you can just certify a class on the fly. If that's the ruling, who the hell needs nationwide injunctions? I'm going to grant a nationwide class. Don't call it a nationwide injunction. It's a nationwide class. Don't call it Rule 23. What the hell is the difference? It's the same thing. If you can grant a nationwide class of every illegal alien in the country might be pregnant, right? That's a commonality, I guess, right? What's the point? So if you ask me Thursday, I'm going to say, well, I'm not sure what they're going to do now. They'll just say, well, no nationwide injunctions, but you can certify a nationwide class in a couple minutes. Then we're back in the same exact spot. And the court's not decided this in a decade. I was litigating with the Texas AGs with Andy Oldham in 2015 against DACA. You remember, right? This was a decade ago, 10 years ago, seeking from Judge Haynen down in Brownsville. Remember that? The court hasn't decided this in 10 years. Like, I have a daughter going to the first grade, and she's been alive the entirety of the nationwide injunction debate, okay? Right? This issue just cannot be resolved. And the court will never resolve it. So the other option with birthright is the court just decides the merits. They re-argue the case in the fall and they say, well, the order is unconstitutional, so we don't have to decide the remedial question. Just because there are clearly 8 or 9 votes in the merits. They could just bypass. We're going to pretend they're standing. We'll pretend there's jurisdiction, right? We'll pretend that the states actually have standing here. Or we'll pick one pregnant woman who will not be pregnant anymore. Roe v. Wade, capable of repetition, evading review, and she has standing, and they'll just make something up, right? It's almost embarrassing, right? They're trying so hard to look like a court, and the more they try, the worse it looks. Yes, sir.
I'll follow up on that. So nationwide injunction. Is it better for Congress or the courts to decide that, and what do you think they should decide?
Oh, I think it's always better for Congress to decide things. I mean, Rule 23 has its benefits. You have to follow specific procedures. It's binding on all parties, so if you lose, you can't bring parallel litigation in different states. So I think there's benefits for Congress to do this. If the court does, say, well, you can't do nationwide injunctions unless it's really important, right? Or unless a fundamental constitutional right's at issue. Curious how they'll apply to structural issues like the Commerce Clause, right? So I don't know how they get around this. I think what the court's basically going to say is, we, the Supreme Court, are supreme. We're gods, and we can resolve it. So just do whatever you want. Lower court will figure it out. That will end up happening because the Supreme Court says we agree it's nationwide. Cooper v. Aaron, worst Fed court decision of all time, right? Just terrible decision. The court said that our decisions are the supreme law of the land. That cannot be the law, right? The Supremacy Clause does not say Supreme Court's the law of the land. But I think they're going to decide on the merits, and they're going to ignore the issue and pretend it doesn't exist. It's like each case on its own. There are not 5 votes on what to do. That thing's the answer. What else? Going once? Going twice? In the back. Thank you, sir. Yeah, speak up. I can't hear you.
So I'm sort of afraid to ask this question guys asked. So 22nd Amendment, it is undemocratic to me.
A term limits, you mean?
22nd.
Right.
The term limit is undemocratic. You would want that
Okay, so the question was, the 22nd Amendment's undemocratic? Yeah, it is. And in fact, many presidents called for its repeal. Reagan called for the repeal. You can amend the Constitution. If you're asking me, can Trump run again? So the strategy that I've read would be that J.D. Vance runs for president, and then Vance resigns, and then Trump is elevated. And super technically, the bar is being elected president twice, not serving president twice. I think that's not going to happen. I think that we're like in sort of like MSNBC fever swamp, fantasy world. I think we can talk about more salient things. But I agree, it's undemocratic. But look, lots of things in the Constitution are not democratic. Yeah, it's true. Anything else? 1 o'clock. I get to eat my steak now. Thank you all so much.